Hello, everyone, and welcome to the Career Choice Series webinar on trademark law. The Career Choice Series is designed to give law students, young lawyers, and transitioning attorneys a general overview of a practice area and ways to position yourself to get there. The Career Choice Series is brought to you by the ABA Career Center, Law Student Division, Young Lawyers Division, and for this installment, the section of Intellectual Property Law. The section of Intellectual Property Law is the premier forum for students and lawyers interested or working in the scope of intellectual property laws and their fair and just administration. The Young Lawyers Division is here to help new lawyers navigate the early years of their career and law students prepare for life after law school. The Law Student Division offers premium benefits, which includes access and savings for Quimby.com, discounts on bar review programs, and up to $50 off West academic casebooks, and a legal ethics bundle that includes a free model rules of professional conduct ebook. Upgrade to premium for $25 and sign up today at abaforlawstudents.com/gopremium. The ABA Career Center offers both career development resources and a job board for law students and legal professionals across all disciplines and career stages. My name is Lexie Heinemann, and I work for the Career Center and Senior Lawyers Division at the ABA, and I'll be moderating today's program, and starting with introducing our panelists, Kim and Tad. Kim Boyle is Senior Counsel at Dunner Law and previously served for years in-house as Lead Global Program Management Counsel, handling all aspects of IP licensing and brand extension management of a large client brand portfolios. In addition to negotiating and drafting IP licenses and counseling clients on best practices for brand protection, Kim provides strategic brand architecture guidance for portfolio and program management, redesign of IP operational processes, and best practices for compliance protocols. There's so much more to cover, and we'll let Kim get into that in a minute. I'm going to introduce Tad now. Tad Chaloemtiarana is a partner at Pattishall, McAuliffe, Newbury, Hilliard, and Geraldson LLP, one of the oldest IP firms in the country. Tad has focused his entire career on trademark, unfair competition, copyright, and informational technology matters. His experience includes both federal court litigation and transaction work, including negotiation and licensing of all kinds of intellectual property rights in a wide variety of areas. He also serves on the Counsel for the American Bar Association section of Intellectual Property Law, and has served as the membership officer, chair of the Trademark Division, and on the nominating council for the section. With that being said, we will start our program and begin with having Tad tell us a little bit about what trademark law is.
Thanks, Lexie. Well, traditionally, trademark and unfair competition law prohibits conduct that's likely to confuse or deceive consumers as to the source of goods or services. And sort of the classic form of prohibited conduct is trademark infringement, or the copying of brands or trade names, labels, or commercial trade dress or the like. But trademark practice generally is actually much broader than that. It encompasses acts that are broadly referred to as unfair trade practices. So that might include acts that don't necessarily comprise deception as to source, like false descriptions of goods, false and deceptive advertising, misrepresentation claims, trade disparagement. All of those types of claims fall within the umbrella, broad umbrella of unfair competition law or trademark infringement law. And so there are sort of an endless variety of sort of dirty tricks, if you will, or actions that can be said to fall within the umbrella of our practice.
Thank you. Kim, do you have anything you'd like to add?
Tad did a great way of speaking on it. Indeed, what I really liked about what Tad just said was to refer to the legislative intent of the law, and that's something I always keep in mind with clients, is that, really and truly trademark law originates from the desire to protect consumers and to know that certain products and services are derived from certain sources, and that's the way the manufacturers or providers of those products and services distinguish themselves from others. And what's been fun for us in our career, and we'll talk more about it, is just the way trademark law has evolved to cover the expanded areas that Tad spoke of.
Thank you. So moving on, now that we kind of have an understanding of what it is that's involved in trademark law, let's talk about your career path. So since Tad started us off last time, Kim, can you give us a bit of an overview of how you got to where you are, what interested you, etc.?
I'm happy to, and I have a very, an interesting path, and all of my colleagues do. In college, I was a production coordinator for a very well-known society photographer in Dallas, and part of my remit in that role was to understand copyright law, because one of the things that he did was sign his very wall-sized family portraits with a flourish. From that, I got very intrigued with intellectual property law and ended up doing a paralegal certificate and started my career with firms in Dallas, including Sidley Austin, once it had acquired Richards, Medlock, and Andrews, and had built a very wonderful paralegal career that started in trademarks, moved into patent litigation, and then eventually morphed back to trademark. All the way, despite having that great career, I kept my eye on law school. And one of the things that was my sort of final tip over point or trigger point was I had the good fortune of being involved with some wonderful outside counsel and participated in writing a very clever little argument that won on summary judgment. And it was sort of at that moment I said, I really, really, really want to sign what I write. And that was the impetus for me to finally take the plunge and go paralegal to law school.
And Tad, what was a little bit about how you got to your current position, or what drew you to the field?
Sure. Well, my career path was sort of somewhat straightforward in that I was a literature major in college, and having no obvious career opportunities, I went straight from undergrad to law school. And during law school, I took an IP course. I thought I might have an interest in it, but I wasn't really sure. And so I started at a general practice firm in their litigation department. I actually had turned down an offer at my current firm at that time because I wasn't sure I wanted to specialize in IP. But having spent a few years at a general practice firm in their litigation department, I really found that I enjoyed the trademark practice and the IP practice generally. And I don't think I appreciated so much the fact that you could practice IP law without a technical degree, at least in the trademark and copyright areas and the non-patent areas. I liked it enough that I ended up moving to the IP group within this general practice firm within the first year. And then after about 4 years at a general practice firm, I moved to Pattishall, my current firm, which is more of an IP boutique firm. We focus primarily on trademark and for competition law. And I've been here for, going on 20 years now.
It's really interesting hearing the comparison, but between the break-ins to getting to where you are, showing that it doesn't necessarily have to follow one individual traditional sort of look at studying something super technical to moving on to it. So thank you for both kind of getting a little bit into how you got to where you are. And I think what we can, if any, do you have anything to add before we move on to kind of talking about what the day in the life looks like?
Well, I'm happy to add one little, addition to mine, and that is to kind of make that jump from where I left off, entering law school to where I am. I had the good fortune, because of all that background, of having clients sort of waiting for me when I got out of law school. So I did have a boutique firm, and one of my clients ended up needing so much guidance that I went in-house with them. And I had spent most of my career in-house, coming up in brand representation agencies and brand licensing agencies, and then just recently went back into private practice.
I would add one other comment, and that is, it sometimes can be hard to break into IP in particular, and certainly trademark specifically, right out of law school. And so, I think broadening your network, your professional network, keeping an eye on opportunities that pop up in the future are always good things. I didn't know when I went into law practice that I wanted to be in IP, but I maintained relationships with attorneys at my current firm. And so when I was ready to make a move, they knew who I was and I knew who they were. And so, organizations like the ABA, for example, can be good ones to network and get to know other IP attorneys, and you never know what's going to happen down the road.
Yeah, Tad, that's an excellent point. I agree. I mean, I don't know if you were a law student member of ABA. It sounds like you may have been, or at a minimum had it in your focus. Certainly, it was beneficial to me as well. I joined in my first year of law school and took advantage of some of the benefits that Lexie spoke about in the front end of the call, and it certainly has been a wonderful network builder for me as well.
Yeah, I mean, there's truth to hearing the advice over and over again that networking is key. So I'm happy to hear you both attesting to that. It doesn't hurt to have, someone, even if it's just for like shadowing or an informational interview in your network to kind of feel it out if this is something that you'd want to pursue. Going on to the day in the life, you told us about what you do, but that's a little bit broad. So, in your daily duties, what does that kind of look like? What tasks do you have on your to-do list for today, for example? And we will have Tad start us off.
Sure. Well, I will admit that there's no days are really that similar for me anyway. In private practice, I try to tackle emails first thing in the morning, usually well before I get into the office to see if I have any emergency matters popping up. I do a lot of foreign work as well, foreign disputes, foreign trademark prosecution, and so those emails will land in my inbox overnight, and so I try to knock those out. And when I get to the office, I usually invariably have several scheduled meetings, typically client conference calls or in-person meetings, or lunches or other meetings with the firm, and those will be on the agenda. This morning, for example, I met with a client and worked through some issues related to a subpoena that they received in a matter, and so that's pretty typical. Invariably, the unexpected arrives in private practice. Unscheduled client calls, emergency things pop up, or emails with new matters, or what have you. And one of the things that I try to do is carve out some portions of my day to actually do some substantive work. Writing legal briefs or responding to cease and desist letters or responses to office actions, so that I can kind of focus on that and actually get some work done during the day. In my practice anyway, I try to get home and see my family anyway. I get before dinner, and then if I have to work thereafter, I work in the evenings as needed. But my practice tends to focus on both litigation-related matters. Half of it's litigation-focused, and half of it's going to be sort of counseling and transactional matters. So a lot of it's going to be litigation in federal court, trademark oppositions before the Trademark Trial Appeal Board, managing foreign trademark disputes and cease and desist matters and things like that. And then the other half will be kind of risk counseling, if you will, doing trademark searches and clearances for new brand launches, or analyzing risks for clients who want to take certain actions like advertising or launching a new brand. And so that's sort of a sense of what my practice looks like.
Yeah, there sounds like there's no shortage of things to do. Kim, do you have any some sort of similar overlap? What does your sort of day kind of shape up to look like?
Well, curiously, Tad and I do have a lot of overlap in sort of the average day, meaning there's a lot happening in any given day, and it sort of keeps us floating in many different directions. The one distinction would be that I think I have far less in-court litigation than Tad does, save for, opposition and cancellation proceedings before the Trademark Trial and Appeal Board. But certainly, it's a very good divide of strategic counseling, clearance, brand enforcement and protection, a lot of transactional work, a lot of sort of IP portfolio audit work too. When you come from an in-house perspective in the branding arena, you find that you end up doing a lot of sort of architecture guidance counseling for the development of programs internally, and really guiding clients through how they can optimize their IP portfolios, how they can monetize them through licensing and brand extension. And then in addition, and I think this is true for Tad too, when you're involved in some leadership roles or committee chair roles, some of your day ends up getting devoted to pushing those matters forward. But really and truly at the core of it, I really like what Tad had to say about the time management piece. And I find that to be an incredible skill for any of us that practice in an area where we're pivoting frequently between substantive and more spot check type of matters. And one of the things to sort of mirror Thad's comment about email in the morning is that need to carve out specific time to get your head into the deeper dive matters, whether you're going to search and analyze a search, or write an opinion, or go dig into redlining a particularly heavy transactional document. That's a very important piece to give yourself in the day so you can be the best advocate possible.
Thank you both for sharing a little bit about kind of what your days look like. Do you have anything else that Tad, would you like to jump off of anything Kim just said?
I actually maybe we should help define a few things. I sort of mentioned Trademark Trial and Appeal Board, and Kim did as well. But for those of you who are not familiar with it, those are when we file trademark applications, for example, there's an opportunity to oppose by any third party. And that's true not only in the U.S. but also abroad. And also, registrations can be canceled as well. And so these are like administrative proceedings before the Trademark Trial and Appeal Board that involve discovery, that involve brief writing and trial briefs and that sort of thing. So it's very akin to litigation, but it's mostly on paper for the most part, with the possibility of an oral hearing. And so, there are depositions and that sort of thing that are involved in that. And so that's one aspect of our practice that is quite robust. And it's sort of a proxy in some cases for from litigation in federal court.
Thank you for clarifying that. Yeah, that's actually helpful to know, because some of those things, if you're looking at a sort of general scope, you might not have that sort of insider, because you work with it more regularly, knowledge. I want to kind of bounce as we move along off of what you were saying about, both of you were saying about having like the time where you carve out, and it seems like you guys are both very passionate about what you do and very involved. So if you could think about some things that, the pros and the cons of your career path, let's have Kim start us off with, so what do you love about what you do?
Wow, I could go on and speak for hours about what I love about what I do. And you're right, Lexie. I mean, there really is a passion that goes into that. But if I had to distill it to, kind of a very simple answer, one of the things that really delights me the most about what I do is that we have both sort of technical and creative aspects to our work. I always sort of use the phrase, it's both art and science. And that is really great because it touches both sides of my personality, both sides of my brain. It's nice to work with clients who are, very much in the sort of legal, technical side of things, but then also cross the aisle, as it were, and understand the business behind our clients' brands and their trademark portfolios and copyright portfolios. And it really is. It's a fun challenge to be able to be kind of jumping from thing to thing. And then the final piece of what I love is that I find that the practice of trademark law in particular is something that's very easy for the layperson to understand. So it's a fun thing to get to communicate to family, kids, friends, and colleagues in other practice areas, because everyone is touched by brands daily. So it's a very relevant and understandable area of law, and easy to get excited and kind of inspire people about.
Tad, what are the pros before we get into the cons? We'll start with the sweet stuff.
I hope I could talk more about the pros than the cons, but I will echo what Kim said about this area of law in particular. I think it's a fun area, and it's a very evolving area of law, surprisingly broad in scope. And we're constantly sort of learning and trying our best to keep up to date in applying the law to new facts as they arise. I do remember when I made the transition from general litigation to trademark in particular, that it was one thing I liked about it is that I became an expert, sort of relatively speaking. I developed an expertise in IP law and trademark law in particular that I could then apply against new facts as they arise. And I actually like that aspect of this practice, that you can really develop a knowledge of the area over a period of years. And it's a fun area. You remember the cases because the cases are so distinctive in terms of the nature of the disputes I like that sort of aspect of it as a young attorney in particular. I also tend to like the collaborative nature, at least of my practice. I work with a lot of experts in trademark law and other IP areas, and I like the discussion aspect of it, and the collaboration with my colleagues to solve problems and develop better legal arguments. And I don't think, for that reason, I don't think I'd enjoy so much being a solo practitioner. I do like working kind of in an IP boutique, because in large part, our clients tend to come to us for our expertise, in the area. So those are all aspects that I really enjoy about this practice. Would you like me to go on to the cons?
Both of you emphasized that it was fun for you, and that it actually brings enjoyment, amidst, managing probably a million Outlook appointments, et cetera. But that you are involved and you're staying on top of things. When we get, well, I'm curious to hear a bit about like a challenge, less of a con, but like what's something about maybe just regular parts of your day or just the field that is a challenge that you've had to learn to overcome?
Well, and this is a more recent one. And it's not insurmountable, but it's one that I think any of us who are practicing this area of law need to be mindful of and learn how to make sure we're adding value to our clients around this challenge that I've experienced. And that is that, with the digital age and also with a lot of, just the generational distinctions as trademark law has evolved, there tends to sometimes be, and I'm not going to necessarily make this a very broad general statement, there tends to sometimes be a notion that trademark law is easy or DIY. And a lot of times we find that people will come to us after they may have tried to search and or clear and or file their own trademark application but really didn't have the knowledge to understand how to properly craft a recitation of goods and services that would have the best opportunity of proceeding through a trademark prosecution smoothly. And while on the one hand, it's fantastic that, we might have a client that comes to us in a period of need because they're at a place where they're on a final office action rejection or something like that. It's a place of law that I've thought, all of us, and Tad touched on it, it's that constant evolution and understanding the new developments that keep us kind of on our toes and adding value to our clients, not just our in-house lawyer clients, but also, the business clients and the aspects of the brands that are really thinking about, well, this is easy. And, there's a lot of aspects of any law practice that might seem fairly straightforward, but really and truly, there's such nuance and such experience that goes behind truly great representation and practice in this area. So that's kind of a challenge. It's not a hate. It's not a I don't like it. It's just something that I think a lot of us are sort of on alert about.
I agree with you about that, Kim. I mean, there's a lot of pitfalls in our area that people who are perhaps not as experienced could easily fall into. And unfortunately, sometimes we end up handling things that are having to take over things that people maybe made a few tactical mistakes along the way. So I agree with you on that. I'd maybe add one other comment, or maybe a couple of the comments about things that I maybe dislike or like less. And it's not really specific to trademark law, but it's more specific to private practice. And that is, we talked a little bit about being able to carve out time on a specific project or find time. And there are just a lot of distractions. And that's probably true in-house as well. Kim, you could speak to that better than I could. But those are always challenges, trying to stay focused and trying to get work done. And obviously billable hours are a factor in private practice, and something that I probably could go back for over 20 years and track every 1/10 of an hour that I've spent in my life, which is not something that I'm proud of. But that is something that you have to get used to, and it can be challenging for a lot of people.
Yeah, and I'll follow that because I love how we're sort of like, dovetailing off of each other. You're absolutely right. The distractions are present whether you're in private practice or in-house, and certainly in-house and or in private practice, if you also happen to be leading a team of any size, you also kind of are in that role of being a leader and a mentor and having sort of staffing issues that you're dealing with too, which are, clearly non-billable. But there's an interesting point, in private practice, obviously, the billable hour is the thing. And while perhaps in-house counsel have, and I'll use my air quotes, the luxury of not being a billable hour entity, likewise, it's always interesting and challenging when you're in an in-house role to have leadership understand the value that you add as an in-house counsel, because it's difficult to measure the efficacy and performance of an in-house counsel without a billable hour. I mean, you're not selling, so you don't have, a number on your head, as it were, to hit a particular metric. And how do you define what we do? Does filing X number of trademark applications count? Does, writing X number of agreements count? So it's an interesting challenge that I think in-house counsel face. And the best way I've been able to navigate that is just, constant interface with leadership, showing how you add value in very real and tangible and, face forward ways.
That's actually the perfect point to segue, and I want to kind of continue what both of you are saying with this, because you mentioned that, being organized and having really good time management skills are critical to being able to manage the sort of work that you're juggling all the time. For someone looking to break into this field or to get into a similar position, what are some sort of key skills that you think potential IP lawyers, trademark lawyers should know before jumping in? So let's continue with Tad.
Sure, happy to do that. I think the first thing is that you need to have a sense that you have a natural curiosity about this area of law. It's a really quickly developing and changing area of law, and you really do need to kind of be prepared to keep up. And so, I review, and I'm sure Kim does, new decisions and new rulemaking on a very, very regular basis. And that's something that I'm interested in because I feel like I need to know it, and I can reflect on based on past experience. And so certainly my work with the ABA intellectual property law section has helped a great deal in terms of keeping up to date and teaching as well and those sorts of things. But that's something that you're going to have to demonstrate an interest and an ability to do that on top of all your other obligations. A couple other skills I think that are probably important for a lot of different practices, of course. I really think obviously strong legal writing and analytical ability is an absolute must. I mean, a lot of what we do is on written briefs or written communications to clients and that sort of thing. And so being able to be clear and concise in your legal writing is absolutely critical. And something I think maybe is a little underappreciated perhaps in law school and in undergrad is having strong public speaking skills. I really feel is important. We have to clearly and thoughtfully articulate our analyses, not only to a court, but also to our own clients, particularly if you're outside counsel and also if you're in-house counsel. And so taking a public speaking course or doing a lot of public speaking helps a great deal, I think, in our practice. So those are three things that I was thinking about.
Kim, do you have any overlap with that, or what are some skills that come to mind that you think would be good for people to develop?
I agree with everything Tad just said, and certainly have seen all of those things also come true in my own practice. And kind of expanding off of those, the curiosity, obviously, about evolution and case law and keeping up on things is definitely true. And I would extend that into, and I say this largely from the perspective of all my in-house counsel experience, being a consumer, understanding and having a curiosity about the market and the changing market. So not just the legal side of IP, but the marketplace-centric side of IP and how brands work in the market. And I think that especially is helpful when you are advising in-house counsel. And when you're advising in-house counsel, remember that your in-house counsel is in turn advising his or her leader colleagues, the business side, their stakeholders in their organizations. So to Tad's point also about being a very good writer and a very compelling writer in a way that not necessarily is always legally heavy, but that your clients can discuss it internally and apply it to their situation in a way that shows your understanding and analytical ability, not just legally, but also practically and pragmatically. A lot of that is balancing, cost and benefit analysis and risk and understanding your client's needs and tolerances and latitudes in that area. And then finally, again, right with you, Tad, I completely agree on the public speaking skills. It's a place where you can take your career really to another level if you have the desire and ability to speak and present and get involved in leadership roles that also afford you that opportunity.
Yeah, I'm glad you touched upon that. It makes sense that you both are presenting, and public speaking does keep you sharp, and if you're excited about what you do, it's fun to talk about what you do. So thank you for kind of giving some insight as to what would be beneficial for a law student or a transitioning attorney to think of as they're honing in on these things to move forward. So you kind of mentioned there's a lot of curiosity involved with wanting to know more, but kind of jumping off of that, what's something about working in trademark law that was surprising to you when you started, or that people might not know off the top of their head. Kim, do you have anything that comes to mind?
I do. What's surprising about trademark law is its breadth and its reach into other areas of law. And I say that from this perspective. So, a lot of us come into the IP law practice, and in particular here we're talking about trademarks, just thinking about the trademarks themselves. But what's been really amazing to see over the years of practice is just how integral trademark law is in other areas. So, for example, merger and acquisition agreements, trademark licensing. If you happen to be someone who represents talent or celebrity, how much personal branding and whether a trademark exists for a human or a voice or anything like that comes into play. So, I think Tad mentioned it earlier about the idea of working collaboratively with colleagues and even sometimes across practice groups is we are very much not a one law island, and it's been very gratifying to see how we are able to help our colleagues understand pieces of agreements that might not be considered in our practice area but certainly have overlap.
I love that. Yeah, the island.
I'd follow up on that, Kim. I think you're exactly right. And it's something maybe I certainly didn't appreciate as I was starting out in practice. The sheer breadth of what there is to learn in this area it's not a niche, if you will. It actually involves a lot of different sort of different doctrines and different things you have to understand and get your head around, including things like the differences between federally registered marks and common law. The substantive differences between proving infringement versus dilution versus unfair competition under Section 43A of the Lanham Act. And there's a lot of sort of procedural things that are unknown when you come into this that you need to get your head around, including trademark application practice, both U.S. and foreign, if you do foreign work. And if you're a litigator, obviously you have to have a understanding of the federal rules of civil procedure, as well as the rules of the Trademark Trial and Appeal Board, which are very different in many instances. And so there's a lot to get your head around in this area. And for that reason, I think people may not fully appreciate how much there is to learn.
Yeah, when you said that there was a broad scope, it's kind of hard to register that, a voice could be trademarked and that's only one part of it, and that there's a denser side to it. It involves reading, and you guys emphasize several times staying current is a huge part of what you do, and that's definitely no small feat. Kim, do you have anything you'd like to add?
I think that's the biggest surprise for me, but it's a good surprise. I think Tad and I agree on that one.
Yeah,
absolutely.
A good, happy surprise. So our last slide before we have some questions that have come in. So before we get to the Q&A in just a moment, I kind of want to tie it back to what Kim had mentioned in the beginning about networking and being involved in the ABA. So we just wanted to take a moment and ask, how has being involved in the ABA boosted your career? I know we mentioned networking, but Tad, why don't you start us off?
Sure. Well, I've been very involved over the years in the substantive work of the section of intellectual property law, and particularly on the trademark side. I mean, in addition to doing some teaching work, I've worked on a number of the different committees within the trademark division. I was vice chair and chair of the trademark division itself, and now I'm on counsel, which is involved in developing policy issues, for, among other things, for the section and for the ABA as a whole. And so that work, I think, has benefited me a great deal in terms of, in particular, simply understanding the different issues that are arising, the hot issues of concern, and helping me to stay up to date substantively on the law. In addition to developing sort of outward credentials, which are, I think, useful, obviously, in private practice, and I would say that one of the untold benefits is that, I've made friends, frankly, with a lot of people, both in-house and outside counsel within the section. That network has benefited me a great deal in private practice, in terms of being able to find, if I need local counsel in different states, and I do know people through the section. And so it's been really great for me in terms of building my relationships with leaders in the IP field. And I really enjoyed, frankly, doing the work in the section itself. in particular. It's been a fun area, and it's nice to know that you can have an impact on policy issues as they arise, either in the Supreme Court or even legislative issues.
Thank you. And Kim, I know you talked a bit about networking, but is there anything else that you want to expand upon?
Definitely. And you know, aside from the initial joining ABA as a law student and kind of getting my feet wet in networking in that regard, it certainly has carried over into my career. And interestingly, you know, when you're in-house, there tends to be less of a focus on action and activity in the ABA, because as an in-house lawyer, you're rarely a litigator, and there has traditionally been a focus on litigation, although I certainly would say and agree with Tad that, you know, the programming that the ABA offers is far broader and more expansive than that. But most recently, some of what's been really great is that kind of reconnecting with the ABA as I transitioned back out of in-house practice into private practice is the opportunity to get involved in a very leadership-related way, chair committees, you know, as Tad pointed out, get involved in policy. And interestingly enough, the jump back out into private practice was directly related to relationships that I built from my ABA membership. And, you know, had those relationships not come from that, you know, maybe the timing would have been different, or the opportunity would have been different. So it's an invaluable organization to be a part of for many reasons: the education, the programming, the leadership opportunities, and the networking.
Thank you for sharing. That's a really good emphasis on leadership, tying back into the skill portion of just like constantly honing what you do and expanding and learning and broadening your horizons and kind of like immersing yourself into it a little bit. And it's another good segue, since we have some questions that have come in and I want to make sure we have time to answer them. We will start with one for Kim. Kim, can you please expand about the in-house counsel rule of applying non-legal analysis to risk cost benefits analysis?
Be happy to. And it actually requires you to sort of wear two hats and be able to understand the fly zones for each when you're in-house. I mean, you need to always be mindful of what's the practice of law and what's not, and who your client is. And that's challenging, especially in the agency sense, because your client is always your employer. You're the in-house counsel for that employer. So, for example, in the agency sense, you are advising the client, your employer, on their rights under a representation agreement with an outside client, for example. In the agency sense, for brands that are owned by your client, your employer, obviously you jump in on that aspect. But interestingly, when your employer is an agency and employs or is retained by outside clients, you tend to switch over into the strategic business mode of non-lawyer practice. But the benefit to the client externally is that you are a lawyer, so you understand how to navigate your way around a contract while also advocating for the representation of that client's brand. And it does require you to be both cognizant and appreciative of all the new developments in the law, but also developments in the market, particular to your client's products and services. So, you know, it's an interesting place to kind of flip those hats on and off. And again, it goes to that enthusiasm and curiosity for this area of law and for brands and markets in general.
Thank you. Okay, so for our next question, after 5 years of doing IP work, how hard would it be to transition to a different practice area? What practice areas would be aligned with transitioning to? Do either of you have a comment you'd like to make on that?
You know, that's a great question, and I guess it depends on the nature of your IP practice, right? I mean, if you're focusing on patent prosecution, for example, you might have a different series of options, I think. And if you do litigation versus non-litigation, your options after 5 years might be very different as well. I think it really depends a great deal on sort of where your focus is. I think if your practice is primarily in your sort of in the trademark and upper competition field, and you're looking to make transitions to other practice areas, certainly, you know, if you're doing more transactional work, I would imagine, a corporate practice of some type, M&A or other things like that might be something that you can transition to. I've known people who have transitioned to a variety of different areas, not necessarily IP focused after they've had a strong IP background, but moving in-house, for example, to in-house corporate positions that have developed, started out as more of an IP focus, but then sort of moved on to much broader business law type of practices. I don't know, Kim, if you have any other thoughts on that.
Well, I would agree with that. That's where my brain went first, was assuming that we're talking about someone who's been in IP law for 5 years and has focused more on the transactional side. That corporate transactional practice jump is the most relevant to me, especially on the M&A side, or any kind of like sort of the formation of a business to the degree that you can apply, like from the starting gate, the notions of IP and rights associated with building a business. But again, and Tad, you might have a sense of this if you have a strong litigation background, even if it's an IP, if you understand federal procedure and that kind of just standard great litigation practice, it might also translate into sort of general business lit as well.
That's a great point. That's definitely true. I mean, certainly the skills you need to be a good IP litigator are easily translatable in the litigation of other types of substantive matters, and so you're going to have a strong understanding of the federal rules, for example, and procedures in litigation in the same way that you would for a general litigation practice. So it's probably not too difficult to transition to go into general litigation or litigation in related fields from a trademark litigation background.
Kind of going off of what you said about, well, let me backtrack. So we're talking about transitioning, but we have a couple questions regarding breaking in still. So earlier we talked about a bit regarding the education. So a few that we can kind of bundle together. Okay, so for the first one, would you recommend an LLM, or how would you sort of recommend people, like with their grades or whatever, are those highly focused on, or should they be focusing on creative things? Is a lack of a science background going to hinder law students? So kind of looking for some more detail on how to get out of school and into the field. If anything jumps to mind for you, Kim?
Well, certainly, if your focus in IP is patent related, you're going to be well served by having a technical background. There's just no way around that. Even if you decide you want to be a patent litigator, having the technical background is key, because you need to understand what you're litigating, the claims of a patent. From the and I almost don't like to call us the soft side of IP, but from the less technical side of IP, there's a lot of ways to craft the right education going in, and certainly I'll say that, especially in my role as chairing the GRIT subcommittee for the IP section, there's a lot more than just your school or your GPA. That those are important, of course, but really the tenacity, the wanting to understand, the wanting to maybe shadow someone in another practice area, or offer yourself up for opportunities to kind of cross over and understand how things work in other practice areas and how things can relate are important. I mean, I think I'll touch on the words that Tad and I have used over and over today, and that is just a true natural curiosity and energy for this area are things that are going to get you a lot of good footing, especially if you can kind of align yourselves with people whose work you admire or respect, and who you'd like to seek out as mentors. And the ABA is a great place to meet those people as well.
I would maybe also add, at least from the perspective of a law firm that hires young attorneys, that the thought does typically cross at least my mind and probably others that if you're going to be focusing in particular on getting a job at an IP boutique firm, or in a department specifically focused on trademark law in a general practice firm, the question is going to rise, what's the basis of your interest? And so to the extent that you can demonstrate some experience, or some, certainly taking a class, an LLM, certainly an IP or trademark law, that demonstrates an interest in this area of law, and helps to credentialize you as a young as a law student or a young lawyer to getting involved in it. And as Kim mentioned, the ABA does have a lot of opportunities for young lawyers and law students to get involved and demonstrate an interest in the area. So if you do have an interest, having something demonstrable is going to be useful, no question about it, rather than somebody who's coming out with no apparent connection to IP or trademark law on their resume, I would imagine it would give you a step up, certainly, to have something on your resume that reflects that interest.
Agree.
Thank you. I think we're running out of time, but I think we have time for one more question. So when you're talking about your practice, do you have any that's multi-jurisdictional? Are you able to represent clients nationally and internationally with your bar licensing? Tad, do you want to start us off?
I'd be happy to speak to that issue. I mean, obviously, subject to the rules regarding unauthorized practice of law, we advise clients about issues that relate to federal statutes. Generally speaking, our practice is nationwide, certainly to the extent that, and most IP firms will be nationwide to the extent that they're dealing with issues for clients in various jurisdictions. When we have litigation outside of a jurisdiction that one of our lawyers practices in, we engage local counsel, of course, and are admitted pro hoc vice in litigation, and that's not an issue. Practice for the Trademark Trial and Appeal Board and the USPTO can be done by any licensed attorney, certainly. So that's not an issue either. We do have, expertise in laws relating to trademark practice outside of the U.S., and we engage networks of foreign attorneys, foreign IP lawyers to provide guidance to clients in those instances as well, and provide some strategic thinking about that. But generally speaking, a lot of trademark law is going to be governed by the Federal Lanham Act, and less so in most instances by state trademark law. And so, you're not necessarily going to be limited in your practice in that regard to the state that you're in.
Before we wrap up, Kim, do you have anything you'd want to add to that?
Everything Tad said is exactly accurate and certainly reflective of how any of us operate in outside practice, because we largely do practice federal law. The particular state in which your primary bar membership or primary admission is less of a factor. As Tad mentioned, when you want to litigate, you can certainly enter a jurisdiction pro hoc vice or with local counsel. Same thing with prosecution outside the boundaries of the United States. We always work with, local counsel of record. In-house practice is also an interesting thing. Similarly, in-house practice, most states will say you may practice as an in-house lawyer under their bar rules, and some of them will require that you make it an affirmative waive in. Many do not. Some of them require something mere as registration, and others not at all. So it's worth exploring, especially if you might want to jump from the state in which you're primarily admitted to another area of kind of looking. And in fact, I think the ABA actually publishes a really great kind of overview of all the different jurisdictions, looking at how you can easily move from state to state if you're in-house counsel, and looking at what each bar might require. But certainly, trademark law is largely focused around federal law, so it's not really a factor.
Okay, thank you. So it looks like we've only run a little bit over. There's just so much for you guys to share. I'm like buzzing with how much new stuff is like in the air right now. So again, I just want to reiterate a huge thank you to both you, Kim and Tad, for joining us, for sharing your knowledge and taking the time to give our audience a better understanding about who you are and what you do. We just have some end-keeping notes that I will go over before we end the program. So if you liked programs like this, the Career Choice Series, for a brief overview of a practice area, we'll have 2 additional programs on cybersecurity law and environmental law coming up within the next couple weeks. And additionally, our Career Development Series will have programs on personal branding and putting your social media to work for you. So how to use social media to influence and promote your practice. And for the latest program updates, you can stay tuned to our social media pages and connect with us there. And then lastly, to learn more about who helps make programs like this possible, you can go to our website at ambar.org/careers and view our leadership page to get to know more about our board members. And before you go, we would appreciate it if you completed our short survey. The feedback helps us with planning programs like this. So again, thank you so much, Kim and Tad. This has been so much fun learning about what you do. And we hope everyone has a great weekend.